Thanks for being here. I'm Brooke. I think most of you know me. I'm the Director of Health and Wellbeing here at the Village. And we're so excited to have attorney Katie Casey here with us today, who actually presented for us last year, an excellent program that we also can share to anyone that's looking for it. But she is one of only a few certified elder law attorneys here in Illinois. And her practice really focuses on long-term care planning, estate planning, special needs planning, Medicaid planning, and the application piece, as well as probate and trust administration. A substantial portion of her time is dedicated to helping families to kind of develop a plan of care for a loved one who may have a chronic care need. And so thank you again for doing this for us, and I will pass it to you.
Thanks so much for having me, Brooke, and thank you all for attending. I am going to attempt to share my screen now. Perfect. All right. So again, thank you for coming. I am here today to talk about a topic I address with almost everybody who comes in my door at our law firm, and that is how to create a legal roadmap to aging well. I liken this conversation to a conversation about preventative health care. So we all think about aging in terms of preparing ourselves for being physically and mentally healthy and engaging in practices with our primary care physician, with our healthcare practitioners, our therapists and our counselors on how to prepare ourselves to be physically well and mentally well as we age. We also like to think about aging in terms of our financial health. We monitor our financials. We look at how much we have in savings. We try to calculate a budget of our income and our assets to try to predict how long we can afford to live at our current level and what our future needs might be. It is less common for us to think about legal planning as a preventative healthcare measure. I call it a preventative legal measure, and it's the basic legal steps that we want to take, similar to our annual checkup, our vaccinations, all of our annual screenings that we participate in with the healthcare system on a legal level, for the purpose of making sure that we don't have a legal crisis as we age, or we don't encounter a legal problem that requires many, many hours spent in a lawyer's office or many thousands of dollars engaged in legal conflict with a family member or a loved one. So this is really the kind of planning we want to do to prevent problems from happening in the future and to allow ourselves to age well and happily and cost effectively. So really, these are steps, and I call it, a roadmap for aging well, but really these are steps we should all be taking in adulthood to make sure as we progress through the aging process, which obviously starts at birth, that we are prepared for what may lie ahead. We're going to talk about the legal planning that's required to prevent problems in the future by starting with healthcare decision-making, financial decision-making, and then address the legal aspects of care planning to make sure that we are preventing problems in the delivery of care for ourselves in the future, and long-term care costs and how legally we can prepare and anticipate the cost of our care and how our care will be delivered in the future when we need it. So just a quick overview. One of the reasons we have to engage in this legal planning in adulthood upon reaching the age of 18 is because when we reach age 18, we are emancipated from our parents and we are considered our own legal decision makers. So what that means is no one else can make our decisions for us after the age of 18. Unless we have designated a person through a power of attorney for healthcare, or unless they are a designated person under the Healthcare Surrogate Act. Everyone over the age of 18 has the right to make their own decisions. Now, anyone over the age of 18, and the chances increase as we age, can experience a temporary or even a permanent lapse in the ability to make decisions. And it's usually a cognitive issue that's preventing us from making decisions, like a traumatic brain injury, a stroke, dementia, other diagnoses, or it might be a physical impairment that is preventing us from communicating our decisions. Cognitively, we might be fine, but physically, we are unable to communicate our decisions. So we have to have some kind of mechanism in place to designate someone to make our health decisions for us if we cannot. And most people are familiar with the healthcare power of attorney. The healthcare power of attorney is the document where you, the principal, name an agent who is essentially your designated person to make healthcare decisions for you when you cannot make them yourself. We also need to have a financial decision maker, even if we are not a person of great means or wealth. A financial decision maker is someone who has the right to advocate for us on a legal or financial level, apply for public benefits, apply for Social Security, advocate for us with human resources if we're temporarily disabled and unable to work, manage our bank accounts, manage our investments, pay our bills. And those powers fall under the financial power of attorney, which is called the power of attorney for property. A lot of people get confused and think, oh, power of attorney for property. Well, that is for people who have real estate or have a great deal of wealth. Property under the law actually means finances. And so it applies to both income and assets in a bank, and in particular, retirement accounts. Almost all retirement accounts are individually held and fall under the pure purview of the financial power of attorney for property. Now, I expect that a lot of you are going to have questions for me, particularly about powers of attorney for property, because they're really quite complicated. They're the most simple documents to put in place. They're the most inexpensive legal documents you can possibly put in place. And if they work well, they tend to prevent thousands and thousands of dollars in legal problems down the road if you have them in place. But they're not easy to understand and they're not necessarily easy to use. So as you think of questions, and for that matter, throughout this entire presentation, as you think of questions, please feel free to enter them into the chat box. And I am going to hold 15 minutes or as much time as I can at the end of our presentation in order to address the questions you have in the chat box. So let's start with the healthcare decision maker. Everybody should have a power of attorney for healthcare. They're a very easy document to execute. They only require one witness. A 5 wishes document, which is something that you can obtain online, is a document that you can download and complete, and it works as a power of attorney for healthcare. And I believe something like 43 states in the country. So it's a document that travels very well with you. Your power of attorney for healthcare has to be executed when you still have mental capacity to understand what you're signing. You might be struggling with a loved one who no longer has the ability to understand what they're signing and who is past the point of being able to execute a power of attorney for healthcare. And it's one of the reasons why I like to say there's this window of opportunity for all of us to execute our legal documents while we have capacity and before we lose that capacity. Once you sign this document, you can amend it at any time. You can revoke it at any time, so you can change your mind. If you don't like your agent, the decisions they're making, you can easily get rid of them. And it allows you to state what your preferences are in terms of how you want to be treated by healthcare professionals when you are ill and when you are close to the end of your life. If we don't have a power of attorney for healthcare in place, the legislature of Illinois has decided who will make decisions for you. So having a healthcare power of attorney really gives you the opportunity to decide for yourself who you want to make your own decisions, because otherwise the legislature has set out this hierarchy of people who will make the decisions for us. And it doesn't matter if we don't want these people. This is the hierarchy, and it starts with your guardian of the person, if there is one, your spouse, even if you and your spouse don't agree or are estranged, your adult children without any specification as to which one if they don't agree, which is always a problem, and so on down the list. So this is sort of the default mechanism for healthcare decision making. I want to point out that it's not totally fatal if you don't have a power of attorney for healthcare, because we have this backup statute for healthcare decision making. We do not have a similar backup statute for financial decision making. So if we do not have a financial decision maker designated in a power of attorney for property, the legislature has not set out a backup statute like this to designate who's in charge. Meaning, without a power of attorney for financial in place, we are going to require a court-appointed guardian to manage our financial decision making. The most compelling case I think I've ever seen in all my years, and frankly, I've seen more than one, I've probably seen dozens of these cases, is where I will have a married couple where the wife and the husband do not have powers of attorney for each other. And they didn't realize they needed them because almost all of their assets were jointly held, except for one IRA, which was in the husband's name. It's almost always in the husband's name, and the husband will develop dementia, be unable to make decisions, be unable to participate in financial decision making. And the wife will come to me and say, I don't understand why I'm not able to access my husband's IRA. I'm the named beneficiary on the account, but every time I call, they say that I have to put my husband on the phone in order to access money. And I don't understand why. And the reason is because even though you're married, and really they should tell you this before you get married, just because you're married doesn't give you control over your husband's solely held accounts. And IRAs are always, in fact, by definition, individually held, solely held accounts. Beneficiary status doesn't take effect until the account holder is deceased. So while your husband is alive but incapacitated, just because you're a spouse, legally married, doesn't give you authority over that IRA without a power of attorney for property. So it really is fatal if we don't have this document prepared and executed in advance of a period of incapacity, because again, without that, we need to go to guardianship court in order to get access to the husband's IRA. And again, this sort of illuminates why you might think you don't need one, people might think they don't need one, but really everyone, regardless of financial circumstances, needs a financial power of attorney for property. And again, we've got that window of opportunity because you need capacity in order to execute it. And once we lose capacity, we are no longer able to sign the document. And if we do sign it without capacity, it's not legally valid. The agent that you are naming under the power of attorney for property, and perhaps you've been named to act for somebody else, you're responsible for keeping records and accountings of everything you do with the money. You're not permitted to use the money for yourself unless the document specifically provides for that. You're not allowed to gift money to yourself unless the document specifically provides for that. And you are entitled to reasonable compensation for your work because it is a job. You are essentially acting as a bookkeeper and a financial surrogate for another person. Many people think that legal planning can be as simple as setting accounts up in joint tenancy. And this is one of the problems I encounter when I have partnered couples or married couples who don't think they need any legal planning because everything is held in joint tenancy. And frequently their children are trying to convince them, no, you really do need more planning than just joint tenancy. And the reason is because joint tenancy really only helps us if somebody has passed away. And it transfers ownership of the account to the joint holder at that point. It doesn't help us while the person is alive for a whole variety of reasons. It also makes things extremely complicated because both Illinois law, criminally and civilly, believe that if you've put a joint tenant on your account, you've basically given that person all of your money. And so if you make a mistake in who you've put on your account and they leave with all of your money, or they are subject to a lawsuit or child support order, an alimony order, or some kind of judgment, they can use all of the money in your bank account in order to pay that off. In fact, it can even be garnished, which makes joint accounts extremely dangerous and very, very ineffective for legal planning. You'll see the risks I put on this page here as to why joint account provisions are very, very dangerous. They're extremely common, with partnered couples and married couples. And for a lot of accounts, it really is the only way to operate when we're partnered or married. It's not a wise choice if we are single or widowed and we are putting a child, a friend, a neighbor, a colleague, or someone on that account for purposes of convenience. Can also cause enormous Medicaid issues as well. Not everybody needs a trust, but most people I encounter really want one. And the reason they want one is because they are considering that their legacy to their loved ones after they have passed away is more a gift of time and convenience than it is a gift of money. So it's one thing to leave somebody a great inheritance, and that's wonderful. It's a wonderful gift. It's a whole other thing to leave somebody the convenience and the time savings of an easy estate transition. And what a trust really does is effectively transfers your assets when you pass away to your loved ones without probate, without a court proceeding, without the involvement of expensive lawyers, and without a lot of time, trouble, and headache on the part of your loved ones. So I always say, if you want to give the gift of convenience and peace of mind, use a trust. It just prevents lots and lots of problems for your loved ones. I frequently encounter seniors who don't want to engage in legal planning at all. They really don't think they need it. They don't want to think about it at all. And the one thing that often persuades them to start thinking about it is that they genuinely don't want to be a burden on their loved ones. They really do want to make things easy. And they think by doing the legal planning, they're going to make things harder for somebody, when in fact, by not doing the legal planning, that is when we make things harder for our loved ones. So engaging in the legal planning, putting a trust in place, just makes everything administratively so much easier and more time efficient for our loved ones. It's really a greater gift than money. So most people have revocable trusts, and you might have a revocable trust. If you don't, you probably have a friend who has a revocable trust. Revocable trusts are extremely popular because they belong to you. You are in control of them. You can change them, amend them, revoke them, take them back at any time, as many times as you want. I've had clients who amend their trust on an annual basis. It's your money, you're in control of it. And what it does is it puts your money in a tidy little package administratively so that you can pay your bills easily, invest your money, transfer assets, manage everything super easily while you're alive, and allows your designated successor trustee to manage everything very, very easily while you're alive but incapacitated, or after you're gone. So trusts are very popular, not just with my clients, but also with the financial institutions. Our banks and our investment houses very much like working with trusts because they're safe. They're a very safe legal mechanism where we can hold our assets and invest it how we choose. And it's very easy for the bank or the financial investment house to know who they're dealing with, who's in charge, and how to move money around accordingly. So it saves people time in a lawyer's office, essentially. Even better than powers of attorney, which are still critical. You still have to have them if you have a trust, but having a trust saves you hours in a lawyer's office, saves you legal fees in administering assets during your lifetime and after. Some people use trusts for tax planning. We do not do tax planning at our firm. Most people with tax planning issues are people of very high net worth. In Illinois, the estate tax threshold is $4 million for an individual, $8 million for a couple. And at the federal level, I believe it's over 12 or 13 million per individual, and double that for a married couple. So we typically don't see that kind of planning, but we do see a lot of disability planning. And a lot of my clients will come to me with an interest in a revocable trust because they are trying to plan for somebody in their life who has a disability. It might be a spouse who has Parkinson's. It might be a brother who has Alzheimer's. It might be a child with autism. It might be a friend who they're leaving their legacy to, who has a disability. Anyone with a disability can easily be taken care of in a trust document in a safe and secure way that makes sure that the money is managed properly for their care needs. And also, if necessary, that it's managed in a way that does not interfere with their public benefits, such as Social Security or Medicaid. So sometimes we worry, gosh, maybe it's too late for us to do a trust. We waited too long to do our legal planning. Can we still do a trust? And actually, there are a lot of opportunities under the law to get trusts in place later in life, even better opportunities than with power of attorney for property. So with a power of attorney for property, you need contractual capacity to execute it. You need to be able to make a business decision. That's a pretty high standard. But with a revocable trust, you actually only need testamentary capacity, which is the same capacity as that required to execute a will. And it involves 3 elements. 1, you need to know who you are and who your loved ones are. You need to know generally what you own and possess in terms of your assets. And you need to be able to come up with and communicate a plan of how you want to share your assets amongst your loved ones after you're gone. It's a pretty low bar, and it's not uncommon that people in advanced stages of dementia are able to execute a plan like that. So just testamentary capacity for a trust, and even if we've got a guardian appointed for somebody in court, they might still have the ability to execute a trust, or the guardian can get court authority to execute the trust for them. If you're acting as a trustee for yourself, it's pretty easy. You're basically just acting like yourself, and you're managing your finances the way you otherwise normally would. You don't feel any change at all for having a trust. In fact, you're using your own Social Security number. There's no special EIN or special tax return when you're acting for your own trust. If you're acting for somebody else's trust, there are duties imposed on you. You are a fiduciary and you are responsible for doing things correctly. And you do have the duty of being loyal to the person you're acting for using the money for them and not for yourself, and for keeping good records and accountings. I find really that the main disadvantage of a trust is that it requires pre-planning. So you got to get into the lawyer's office in advance, and it's an investment because it is more expensive than a simple will to set up. It's also a little bit more time consuming in the beginning because you're putting all of your assets in trust. The cost, though, what I found over the years is that when it's done well, when you do it far enough in advance, when you properly fund your trust, the cost and the time in setting it up is a fraction of what the cost would otherwise be if you didn't do it at all. So I really recommend to people, if you think you are going to pass away with assets and your primary goal is to make things easy for people in the future, do the work now. You do the work now. Do your trust, get it funded, spend the money now to get it all set up, because you will save them time, headache, and lots of legal fees in dealing with it on the back end. If you really don't think you're going to pass away with assets and you're not too concerned with how much time or trouble it's going to be for your loved ones after you're gone, then don't do one. Wait and see how things play out at the end. But as a preventative legal measure, it's extremely effective at minimizing problems and legal fees if done properly in advance. Some people have irrevocable trusts, and you might think you have an irrevocable trust. You know you have an irrevocable trust if the document says that you are not permitted to amend or revoke the document. So if it does not give you specific authority to amend and revoke, you're dealing with an irrevocable trust. If your spouse has passed away and left a trust, that trust is now irrevocable because your spouse is gone and they can't revoke it anymore. If you're setting up a special needs trust for a disabled child or loved one, that is generally an irrevocable trust that once you set up, you can no longer take back. Some of us will have a trust under our will. So for some clients, we don't need a big fancy revocable or irrevocable trust. We just need a simple will. And under that will, we can have what's called a testamentary trust. It doesn't avoid probate. We're still going to probate, but it might be useful if we have a simple estate and maybe minor children are involved. And under our will, we can say, when I pass away, whatever I have, I'm leaving to my minor children under these testamentary trusts so that the money's managed appropriately until they turn the age of majority, or however old we think they should be before they receive an inheritance. And the special needs trust is really a favorite of mine because special needs trusts are established under the policy that if you are living with a disability, then you should be allowed to have more in assets than the Social Security and Medicaid rules otherwise allow you to have. Because living with a disability is expensive. It is more expensive to live with a disability than without a disability. So a special needs trust is a provision carved out under the Social Security Act that essentially says, if you have been determined disabled by Social Security or by a local public benefits organization like Medicaid in Illinois, then you are not forced to reduce your assets down to the $2,000, that's the limit for Social Security, or the $17,500, that's the limit for Illinois Medicaid, if you have your money in a special needs trust. So essentially what it's saying is, if you have a disability, we want you to apply and qualify for public benefits, even though you have money and more money than you otherwise would be allowed to have, as opposed to a non-disabled person. So non-disabled people are required to spend all their money down before they can qualify for benefits, but people with disabilities are not if they put their money into a special needs trust. And again, the policy is, if you are living with a disability, you should be allowed to keep more than those bare minimums. The catch is this, there's always a catch, right? So the catch is, if you put your own money into a special needs trust, then it must state that the money is going back to the Medicaid agency if you've received Medicaid benefits during your lifetime, to the extent that Medicaid has paid for your care. Social Security doesn't take any payback. I don't know why, but they don't. It's just Medicaid that wants the payback. So if you want to set up a special needs trust for yourself, that trust has to say, when I pass away, the balance, anything that remains, first goes to pay back the state Medicaid bill. Then anything left over after payment of that bill can go to whomever I choose to receive that inheritance. Another catch with the special needs trust is that a law was passed just in the last decade or so where people over the age of 65 are no longer explicitly permitted to have a special needs trust with their own money. It is still possible to do a special needs trust for people over the age of 65 with your own money, but it is much more challenging now with the new law that's passed. So the type of special needs trust that we do where we're funding it with our own money is more typically for people who are under the age of 65. Now, there are other kinds of special needs trusts where we can do them both before and after 65 with no problem. And that's the kind of special needs trust that we set up for somebody else with our money, not their money. So a very, very large part of my practice in estate planning and disability planning is including a special needs trust for a loved one with my client's money, not with the disabled person's money. It's called a third-party special needs trust. This is where you're setting up a special needs trust for your spouse or your partner with your money, not with their money. And when you do that, you can do it before and after the person is 65 years of age, and you can do it without any payback to the state for Medicaid benefits. So a third-party special needs trust requires no payback at all to the state for Medicaid. This is really, really important if you are a primary caregiver for somebody with special needs, like a spouse, partner, or an adult disabled child. And this is where in your own estate plan, in your will or your revocable living trust, you can say, upon my death, I leave everything I own to my husband through a special needs trust. And that special needs trust will make sure that your husband continues to qualify for public benefits. And it will make sure that the money is protected and managed by a trustworthy individual. And it will not have to go back to the state of Illinois Medicaid program for any payback after your spouse passes. So this is a very effective strategy if you do want to make sure your children receive an inheritance after your spouse is gone, where you can say, I'm leaving everything to my spouse to a special needs trust. He is in a nursing home. He is receiving Medicaid. He will continue to keep his Medicaid even though he's received an inheritance from you. That money can be used for his benefit while he's alive, but the remainder does not go back to the state of Illinois. It will go to your children or to whomever you want to receive it. The most wonderful part of a special needs trust, in my opinion, is because the policy acknowledges that living with a disability is more expensive than living without, is the money in the special needs trust can be used for things that Medicaid or Social Security don't pay for. And this is why it's also often referred to as a supplemental needs trust. We are trying to supplement the care that Social Security and Medicaid are providing. So a special needs trust, the money in it can be used for things like hiring a geriatric care manager to manage the care and advocate for the good care of your loved one. It can be used to pay for companion caregivers to come and spend time with your loved one. I often think of this as sort of a caregiver replacement strategy. So if I am leaving money to my husband, who is a disabled person, upon my passing, my first fear is who's going to replace me as the primary caregiver? Who's going to be there in the evenings to read to them? Who's going to be there to deliver the special foods that they love? Having a special needs trust means that the trust can pay for a caregiver to replace the things that I've been doing for my spouse. For adult disabled children, it can also be used to really enhance that child's autonomy and independence. So we may have a child who's living with autism, or a developmental delay, or a traumatic brain injury, who can't work, but who is still participating and should be participating in life in terms of recreational activities, educational activities, trips, and sports, cultural events, religious activities. And the special needs trust can be used to pay for all of them. It can be used for tuition to go to school. It can be used for transportation. It can be used for educational equipment like computers and iPads. It can be used to take somebody on a cultural experience or a vacation. It can be used to purchase just the basic things like special clothing or sports equipment that they might need to participate in an activity. So it really can be used to foster and support somebody in their living experience on top of the public benefits they're receiving, because the public benefits aren't going to pay for all of those things. The public benefits are really only going to be paying for basic room and board and basic health care. I particularly like special needs trusts for various therapies. Unfortunately, most basic health insurance and the Medicaid program and the Medicare program too are very limited in how much therapy they provide. Both physical, occupational, speech, and mental health therapy, art therapy, animal therapy, these therapies, the benefits for them is really truly limited. So if you are living with a lifelong disability, the opportunity to have assets set aside in order to supplement the payment of those therapies is really, really a wonderful thing. So special needs trusts are sort of our way of making sure that our estate plan is providing for someone we love on top of the public benefits that are going to pay for their basic needs. And this gets us to the problem of care planning. And one of the reasons we are engaging in this legal planning is because having these documents in place, making these decisions in advance, helps us put in place a care plan that's going to take care of ourselves or take care of our loved ones after we're gone. And to talk about care planning, we really need to first talk about what documents you're not going to get from the lawyer. So getting the basic documents in place from the lawyer is going to involve the power of attorney for healthcare, the power of attorney for property, a revocable trust if appropriate, a will if appropriate, a special needs trust if appropriate. It's not going to include the POST. So the POST is a document which is really, it's the long title is the practitioner's order for life-sustaining treatment. I don't know why they changed it. It used to be the DNR, or the do not resuscitate order, which was a lot easier to say. The POST is the new DNR. What this document does is it allows you to choose your preferences for when and to what extent you want to be resuscitated or kept on life support in the event of an accident, an injury, or a very serious disease. This is not a document you can get from your lawyer. This is a document that right now under the law, you can only get through your doctor, and it has to be signed by both you and your physician, in addition to a witness. So I provide my clients with instructions on when you should consider a POST, how to execute it, but this is a document you need from your doctor. It's also a prerequisite for hospice care in Illinois. So not for palliative care. Palliative care is pre-hospice and does not require a POST. But once we enter hospice, the hospice stage of treatment, at the end of our lives, a POST is necessary. So this is something we want to consider in advance when we can still sign it, or make sure that we've got a power of attorney for healthcare who will have the authority to sign it for us if we can't. I also strongly recommend the utilization of the 5 wishes, and I hand them out to all of my clients like Halloween candy. This is the document I mentioned earlier that you can easily purchase and download from the internet. I get them for about $1 in bulk, but I think you can probably get one for maybe $5 online. If you execute it properly with witnesses and notaries, it does operate as a legally effective power of attorney for healthcare in 42 states, and it is available in 29 languages, which is wonderful if you're working with a loved one or a parent whose first language is not English. This is a workbook that reads very much like a third grader's word problem workbook, but it is about the topic of death and dying. It walks you through the various scenarios that are likely to happen to you at the end of your life, and the things that healthcare providers are obligated under the law to offer you and will provide you with unless you say no. So it really gives you an opportunity to direct your care in the future and to give some assurance to the people who are going to be making decisions for you at that time that they are doing the right thing for you. It really is a wonderful gift to have it laid out, gives your healthcare decision makers great peace of mind to know they're doing what you would have wanted them to do. Doesn't leave them guessing. It's a document you can change at any time. And again, you don't need a lawyer for this document. So I strongly encourage everyone to get one of the 5 Wishes workbooks, to sit down with their loved ones and to complete it in their own handwriting, and then tuck it away where everyone will be able to find it when the time comes. So part of the legal planning we're doing is also being done in order to anticipate the possibility that we are going to need long-term care, and to make it easy for us to access long-term care and make it easy for our loved ones to be able to access long-term care for us. It is infinitely easier to access long-term care if we've got our basic legal documents in place in advance of a crisis. So the very last thing we want to be doing, legal planning wise, and this is why I call it preventative legal care, like preventative health care, we want to do it in advance of a hospitalization or a healthcare crisis. The last place you want to be, if you are dealing with a sudden and terrible diagnosis or a very traumatizing hospitalization, the last place you want to be is in a lawyer's office, dealing with very complex decision-making and time consuming projects like creating these legal documents. We want all of that done in advance so that when the crisis happens or the hospitalization happens, that's already taken care of and we can just focus on getting good care. Long-term care is something we are probably all going to need, and none of us want to think about needing it. Long-term care is essentially either medical or even non-medical care, like custodial care or just home care, that we're going to need in order to accomplish our basic activities of daily living. I'm talking about changing the sheets on the bed, getting the laundry done, doing the grocery shopping, meal preparation, basic hygiene, transportation to doctors, taking care of our home, taking care of our yard, just the basic things that we need to do in order to get through the day. Most of us are going to need some amount of care, and some of us will be able to access that care at home and will be able to age at home if the home is an easy one to maintain and aging friendly, as I like to say. Others of us are going to require that kind of care in a more structured environment. Some of us might even choose a more structured environment simply because places like long-term care, I call them, they're often referred to as, and you might have heard of this, CCRCs, Continuing Care Retirement Communities. We have a number of them in the Chicagoland area. They are essentially, I call them college campuses. It's basically a college campus. You have a variety of levels of care, from independent to assisted to memory to skilled care. Those are the graduated levels, like freshman, sophomore, junior, senior, various levels of care. And within that campus, they are providing not just the housing, the room and board, but meals, community activities, transportation to services and recreational activities, etc. So a lot of my clients will actually choose to move into a more structured community like that, even though they could take care of themselves perfectly fine at home, because they want a sense of community. They want a sense of having the ability to socially interact with others at dinner. They want recreational activities. They want the opportunity to be involved and be part of a community. Unfortunately, at this stage in our healthcare system, long-term care, the care we need at home or the care we need in a more structured community environment, is not covered by Medicare or our basic health insurance plans. There is a program called PACE, P-A-C-E, which is a Medicare-funded program, which has launched in some states in the country, but not yet in Illinois, which intends to change this and intends to provide more Medicare funding for long-term care than is currently provided. But right now, and for the imminent future, there is no funding other than Medicaid, which is a program most of us don't qualify for yet. And so our long-term care costs are going to be borne by us out of pocket, meaning we're privately paying for the care that we need in order to, take care of our basic needs. So when we consider Medicare, and here's a little chart for you, Medicare is really only covering our basic health insurance, doctors, physicians, pharmaceuticals, plus up to 100 days of skilled care following a hospitalization. And it's only paying for part of that. Your supplement is what's paying for the remainder of it. It provides home care intermittently, but it's usually only post-hospitalization. It's extremely intermittent, maybe once a week, a couple hours. It is nothing like the level of in-home or custodial care that most people require post-hospitalization or post-rehab. Some people will have long-term care insurance. I have, in my 20-year career, seen maybe 5 clients whose long-term care insurance policies covered the total cost of their care. It's very rare. Frankly, it's very rare that I even see a client with long-term care insurance, but even when I do, the coverage is generally not 100% of care. It is a portion of care for a limited period of time. For example, you might have a benefit like $100 a day up to $300,000 over the course of 4 years, or $300,000 over the course of your lifetime. There's generally a cap both on the daily rate and on the lifetime payout. There are often also limitations on where that benefit will be payable. So sometimes there's a home care exclusion. You cannot use it for home care, or you can't use it for assisted living. You can only use it for a skilled facility. So it's very important to make sure that you analyze your long-term care insurance policy. And if you do not want to read it, and I would not blame you if you did not, to have an elder law attorney read it for you and to explain exactly what the provisions are as they apply to you so that you can make some good decisions about how much to rely on that policy, what you will need to save on top of that policy, and when you should trigger a claim on that policy. So most of us are privately paying for our care, and it's very, very expensive. And the costs have increased astronomically. I think the inflation rate in healthcare and long-term care has been probably the highest of any industrial sector in the market. So we're all experiencing really some serious sticker shock when we're considering how to get a home care worker in place, how to pay for assisted living or memory care or a nursing facility. And so I advise my clients all the time on how we plan for the cost of care, how we develop a budget, and how we figure out where to spend our money first. Do we spend it on home care first? Do we spend it on assisted living? And how long do we spend it in those areas before we start considering how to access public benefits? So I do a lot of advising on the Medicaid program, which is a federal program which provides funding for long-term care in certain settings in Illinois. And it's a federal program and federal money. The state of Illinois administers the program, and so we are applying for benefits in Illinois. I want to point out, so many of us are living in multi-jurisdictions. Every state administers Medicaid differently. So take what I have to say about Medicaid as it applies to Illinois, but if you're considering moving to another state for retirement, if you have a loved one who you're considering moving to another state for long-term care, you've got to consult with an elder law attorney in the state in which you're looking to move to determine how that state administers Medicaid, because it is different in every state. In Illinois, our Medicaid program applies to nursing homes, skilled nursing facilities where you're receiving 24/7 skilled nursing care, supportive living facilities, which look like assisted living facilities in that you have your own apartment and you are provided with come and go services within that setting, and some memory care facilities in Illinois too are starting to get licensed to receive Medicaid benefits. There is also a community care program and an in-home services program for people over and under 60, which provides Medicaid-funded home care services for people living at home. My point in this is that we hope that we are going to have plenty of money to pay for our care. And we hope our legal documents are in place early enough and that they work properly so that we can spread our funds out over our lifetime in order to pay for all of our long-term care. The fact is that based on what we might be diagnosed with, based on what our family situation is, our support system, based on the cost of care we need, we might not be able to fund our own care privately for the rest of our lives. So it is a very good idea to monitor your care needs and your budget as you age in order to prepare for the possibility of requiring Medicaid funding in advance. And again, this is preventative legal planning so that we can ease ourselves into public benefits in advance and in a relaxed fashion. So it's taken care of at a pace we can handle and in a proper amount of time, rather than dealing with it in a crisis. Again, much easier to handle applications for Medicaid and to transition into public funding well in advance with plenty of time, rather than having to do it because of a crisis or a hospitalization. So with that, I am going to see what we've got in the chat box and welcome you all to ask any questions that you've got for me. I think, oh my gosh, we're right at 12:01. So we've used up your hour and it looks like we have answered all of your questions. So you have my contact information here should you need to reach out to me with any further questions. And don't forget to reach out to Brooke as well in the event you need a 5 Wishes. And again, they are available for you to purchase online if she runs out of her supply. Thank you again for joining us today, and I hope to see you all again sometime at a presentation in the future. Thank you.
Thank you so much, Katie, for an excellent presentation, and to all of you for attending. Have a great day, all.